The case will then be assigned to the courtroom or division that corresponds with the number that has been selected by the foreperson, and the courtroom will, that case or those cases will then proceed in those courtrooms assigned for further proceedings. The indictment itself, that is to say the charging document in this case, will be transmitted to the Jefferson County Clerk's office. It will be recorded and made publicly available through that office. And so I will begin the report of the Jefferson County Grand Jury. In the matter of Commonwealth of Kentucky versus Brett Hankison, the Jefferson County Grand Jury charges as follows. Count 1, wanton endangerment in the first degree. On or about March 13th, 2020 in Jefferson County, Kentucky, the above named defendant, Brett Hankison, committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun, into the apartment occupied by initials CE. Count 2, wanton endangerment in the first degree. On or about March 13th, 2020 in Jefferson County, Kentucky, the above named defendant, Brett Hankison, committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun into the apartment occupied by initials CN. Count 3, wanton endangerment in the first degree. On or about March 13th, 2020, in Jefferson County, Kentucky, the above named defendant, Brett Hankison, committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun into an apartment occupied by initials ZF against the peace and dignity of the Commonwealth of Kentucky. Mr. Foreperson, is that the decision of the grand jury?
Yes, it is.
Thank you. Sir, if you would please randomly select a number.
Division 13.
Division 13. Thank you, sir. The case will then be assigned to Jefferson Circuit Court, Division 13. Madam Assistant Attorney General, do you have a motion with respect to bond?
Yes, Your Honor. The Assistant Attorney General asks for $15,000 full cash bond for the defendant, Brett Hankison.
I will grant the motion and assign bond in the amount of $15,000 full cash and issue a warrant. That concludes the business of the grand jury sitting for Jefferson County in September 2020. Thank you, ladies and gentlemen. You may be excused. I'm going off the record.
Issues. Mic test 1 2 3 1 2 3. Mic test. All right. Thanks, everyone.
still a lot of outstanding questions here, and the Attorney General is going to lay out his case just a few moments from now. But we already know the foundation of what's happened here. Basically, wanton endangerment in the first degree. According to Kentucky state law, that happens when a person has wantonly engaged in conduct which creates a substantial danger of death or serious physical injury. Again, this is a low-level felony punishable by up to 5 years. This is not what Breonna Taylor's family wanted to see, not what her mother wanted to see. I've spoken to her on a few occasions, and at one point I asked her if she had faith in the system. She said that she had seen the system fail so many times, she didn't really have faith that the system was going to rule in her favor this time. And even before this happened, Breonna, there was a lot of talk about this particular officer, Officer Breonna Taylor, who, as you know, was fired by the Louisville Metro Police Department for wantonly and reliantly firing his weapon 10 times. And there was a lot of talk among those who support Breonna Taylor and her family that perhaps this officer would be the quote fall guy. And then the reason why they say that is because it's the family's position that all 3 of the officers that day were reckless, that all 3 of them should be held accountable, and at the very least, that these officers should have faced second-degree manslaughter charges. That is not what we're seeing. And again, we're going to hear from the Attorney General, get an opportunity to hear about the case and lay out some of the specifics in terms of how they reached that decision. A lot of concern about what's going to happen going forward. Protests of that nature. Obviously, the Taylor family has called for 3 peaceful protests. We've seen people out there part day in and day out protests for some more than 100 days. Not all of those protests peaceful, but again, the family is looking for peaceful protests. The city of Louisville basically is at a point where they have boarded up buildings in downtown. They also, the mayor at this point has called for curfew starting at 9 p.m. tonight in anticipation of those who want to come out and protest from 9 p.m. until 6 a.m. The National Guard here also activated as a precaution as well. So a lot of moving parts going on here, but one point is clear at this point. Taylor's family definitely disappointed with the outcome of the grand jury. Breonna. Yeah, and just to add to that, I'm sorry. Well, just to add to that, 26 years old, and loved by her family and those who knew her, and this is why it's so very difficult to remember for some of the people to understand the support of the Taylor family as to why the officer showed up in the way they did, why surveying that no-knock in the way they did, using a battering ram to break down the door. Now, again, officers have said that they announced themselves that day, that night on March 13th. That is a story that has been
Good afternoon, and thank you for joining us today. I know that many in Louisville and across the Commonwealth and country have been anxiously awaiting the completion of our investigation into the death of Miss Breonna Taylor. Prior to this announcement, I spoke with Miss Palmer, Breonna Taylor's mother, to share with her the results from the grand jury. Many of you in this room know that I had the opportunity last month to meet in person with her and other members of Miss Taylor's family, including Miss Bianca Austin and Miss Janiyah Palmer. I want to once again publicly express my condolences. Every day, this family wakes up to the realization that someone they loved is no longer with them. There's nothing I can offer today to take away the grief and heartache this family is experiencing as a result of losing a child, a niece, a sister, and a friend. What I can provide today are the facts, which my office has worked long and hard to uncover, analyze, and scrutinize since accepting this case in mid-May. I urge everyone listening today to not lose sight of the fact that a life has been lost, a tragedy under any circumstances. The decision before my office as the special prosecutor in this case was not to decide if the loss of Miss Taylor's life was a tragedy. The answer to that question is unequivocally yes. There is no doubt that this is a gut-wrenching, emotional case, and the pain that many people are feeling is understandable. I deeply care about the value and sanctity of human life. It deserves protection, and in this case, a human life was lost. We cannot forget that. My job as the special prosecutor in this case was to put emotions aside and investigate the facts to determine if criminal violations of state law resulted in the loss of Miss Taylor's life. This included examining the actions of Sergeant Jonathan Mattingly, Detective Brett Hankinson, and Detective Miles Cosgrove, the three officers who fired their weapons in the early morning hours of March 13th. In working with our federal partners on this case, it was determined that while we would share information to advance our respective investigations, we must also maintain some level of separation to ensure the integrity of each investigation. When examining issues regarding potential civil rights violations, we determined that any such violation are better addressed through a federal-led investigation, and issues involving potential criminal acts concerning the shooting are better addressed by a state-led investigation. With this in mind, our investigation focused on the events that took place in Miss Taylor's apartment on March 13th. In the months since taking this case, our dedicated team of prosecutors and investigators with more than 200 years of combined career experience conducted a thorough investigation to better understand the events that led to Miss Taylor's death. The team is here with me today. I want to personally and publicly thank them for their tireless work. These men and women are true public servants who for months have shown up every day with a desire for one thing, and that is to seek the truth. We decided while we would examine materials gathered by LMPD's Public Integrity Unit, we would need to conduct our own independent investigation and start from scratch in the interest of thoroughness, fairness, and finding the truth. There was no video or body camera footage of the officers' attempted execution of a search warrant at Miss Taylor's residence. Video footage begins at the point that area patrol officers arrive at the location. Therefore, the sequence of events from March 13th had to be pieced together through ballistics evidence, 911 calls, police radio traffic, and interviews. We utilized information from the Kentucky State Police, local medical examiners, as well as working with the FBI Crime Lab in Quantico to secure a trajectory analysis and ballistics report. Our team conducted interviews in this case and spent thousands of hours examining all of the available evidence. We concluded our last interview in this case this past Friday and began our grand jury presentation on Monday. As long as the case is making its way through our legal system, I can only speak in general terms about our independent investigation and findings. As the prosecutor, I am prohibited by the Kentucky Rules of Professional Conduct from making public comments that could in any way prejudice this case as it moves forward. Each state has different rules about what prosecutors can and cannot say. The Kentucky rules are clear that I'm prohibited from making comments that could sway public opinion or heighten public condemnation of those involved in the case. These are crucial rules to ensure due process under the Constitution. When prosecutors prematurely release information about the case to the public, it can risk justice by poisoning the jury pool, violating the accused's rights to a fair trial, and even jeopardizing the final verdict. The success of our legal system is predicated on the principle that the accused is innocent until proven guilty. Despite passions, opinions, and desire for every detail to be known, the rule of law must apply. Justice must be done. In the early morning hours of March 13th, officers from LMPD executed a search warrant at 3003 Springfield Drive, apartment 4. This was Miss Breonna Taylor's residence. The officers were advised by superiors to knock and announce their presence in serving this specific search warrant. The scope of our investigation did not include the obtainment of that warrant by LMPD's Criminal Interdiction Division. Federal law enforcement partners are conducting that investigation. Sergeant Mattingly and Detectives Cosgrove and Hankinson had no known involvement in the preceding investigation or obtainment of the search warrant. They were called into duty as extra personnel to effectuate the service of the search warrant. They only had information conveyed to them during their prior briefing. Evidence shows that officers both knocked and announced their presence at the apartment. The officers' statements about their announcement are corroborated by an independent witness who was near in proximity to apartment 4. In other words, the warrant was not served as a no-knock warrant. When officers were unable to get anyone to answer or open the door to apartment 4, the decision was made to breach the door. After breaching the door, Sergeant Mattingly was the first and only officer to enter the residence. Sergeant Mattingly identified two individuals standing beside one another at the end of the hall, a male and a female. In his statement, he says that the male was holding a gun, arms extended in a shooting stance. Sergeant Mattingly saw the man's gun fire, heard a boom, and immediately knew he was shot as a result of feeling heat in his upper thigh. Kenneth Walker fired the shot that hit Sergeant Mattingly, and there is no evidence to support that Sergeant Mattingly was hit by friendly fire from other officers. Mr. Walker admitted that he fired one shot and was the first to shoot. In addition to all the testimony, the ballistics report shows that the round that struck Sergeant Mattingly was fired from a 9mm handgun. The LMPD officers fired 40 caliber handguns. Sergeant Mattingly returned fire down the hallway. Mattingly fired 6 shots. Almost simultaneously, Detective Cosgrove, also in the doorway, shot 16 times. This all took place in a matter of seconds. In total, 6 bullets struck Ms. Taylor. Medical evidence obtained by our team indicates that only 1 shot was fatal. Further medical evidence shows that Ms. Taylor would have died from the fatal shot within a few seconds to 2 minutes after being struck. Detective Hankinson fired his weapon 10 times, including from an outside sliding glass door and through a bedroom window. Some bullets traveled through apartment 4 and into apartment 3 before some exited that apartment. At the time, 3 residents of apartment 3 were at home, including a male, a pregnant female, and a child. There is no conclusive evidence that any bullets fired from Detective Hankinson's weapon struck Ms. Taylor. The KSP ballistics analysis did not identify which of the 3 officers fired the fatal shot. After receiving that information, I asked the FBI crime lab to conduct its own analysis to see if they reached the same results. The FBI ballistics analysis concluded the fatal shot was fired by Detective Cosgrove. Our office looked at both reports to determine if there were major differences in the procedures used by each lab that would have led the FBI to identify who fired the fatal shot. Both law enforcement agencies use similar equipment and analysis, and each lab is highly respected for their work. There was nothing our investigators could point to, nor anything provided by the respective agencies that directly explains why one lab made the call while another did not. I think it is worth repeating again that our investigation found that Mattingly and Cosgrove were justified in their use of force after having been fired upon by Kenneth Walker. Secondary to this justification, the KSP and FBI ballistics analysis reached different conclusions, creating a reasonable doubt in the evidence about who fired the fatal shot. I certainly understand the public's desire for answers, and many have questioned the length of the investigation. Simply put, we had to try every means necessary to determine who fired the fatal shot before the investigation could be completed. With a thorough and complete knowledge of all evidence collected in this case, lawyers with our Office of Special Prosecutions presented the findings of our independent investigation before a grand jury comprised of Jefferson County residents beginning on Monday and concluding today. In Fletcher v. Graham, the Kentucky Supreme Court said that the grand jury has competing but balanced functions. On the one hand, its purpose is to investigate allegations of criminal conduct and determine if there is probable cause to believe that a crime has been committed. On the other, the grand jury serves to protect the public against unfounded criminal prosecutions where probable cause is lacking. The grand jury is unique in our criminal justice system because it operates independent of the court and the prosecutor. The hallmark of the grand jury is its independence from outside influence. This independence is necessary to ensure that justice is done both for the victims and for the accused. After hearing the evidence from our team of prosecutors, the grand jury voted to return an indictment against Detective Hankinson for 3 counts of wanton endangerment for wantonly placing the 3 individuals in apartment 3 in danger of serious physical injury or death. The charge of wanton endangerment in the first degree is a Class D felony, and if found guilty, the accused can serve up to 5 years for each count. Kentucky law states that a person is guilty of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. My office is prepared to prove these charges at trial. However, it's important to note that he is presumed innocent until proven guilty. During the last 6 months, we've all heard mention of possible charges that could be brought in this case. It's important to understand that all of the charges that have been mentioned have specific meanings and ramifications. Criminal homicide encompasses the taking of a life by another. While there are 6 possible homicide charges under Kentucky law, these charges are not applicable to the facts before us because our investigation showed, and the grand jury agreed, that Mattingly and Cosgrove were justified in the return of deadly fire after having been fired upon by Kenneth Walker. Let me state that again. According to Kentucky law, the use of force by Mattingly and Cosgrove was justified to protect themselves. This justification bars us from pursuing criminal charges in Miss Breonna Taylor's death. The truth is now before us. The facts have been examined, and a grand jury comprised of our peers and fellow citizens has made a decision. Justice is not often easy. It does not fit the mold of public opinion, and it does not conform to shifting standards. It answers only to the facts and to the law. With this in mind, we must now ask ourselves, where do we go from here? Will we continue to prosecute the charges brought in this case as it now proceeds through the justice system and moves to trial? That is our responsibility. And this will be done while the FBI continues its investigation into violations, potential violations of federal law. I know that not everyone will be satisfied with the charges we've reported today. My team set out to investigate the circumstances surrounding Ms. Taylor's death. We did it with a singular goal in mind, pursuing the truth. Kentuckians deserve no less. The city of Louisville deserves no less. Every person has an idea of what they think justice is. My role as special prosecutor in this case is to set aside everything in pursuit of the truth. My job is to present the facts to the grand jury, and the grand jury then applies those facts to the law. If we simply act on emotion or outrage, there is no justice. Mob justice is not justice. Justice sought by violence is not justice. It just becomes revenge. And in our system, criminal justice isn't the quest for revenge. It's the quest for truth, evidence, and facts, and the use of that truth as we fairly apply our laws. Our reaction to the truth today says what kind of society we want to be. Do we really want the truth, or do we want a truth that fits our narrative? Do we want the facts, or are we content to blindly accept our own version of events? We as a community must make this decision. I understand that Miss Breonna Taylor's death has become a part of a national story and conversation. But we must also remember the facts and the collection of evidence in this case are different than cases elsewhere in the country. Each is unique and cannot be compared. There will be celebrities, influencers, and activists who, having never lived in Kentucky, will try to tell us how to feel, suggesting they understand the facts of this case and that they know our community and the Commonwealth better than we do. But they don't. Let's not give in to their attempts to influence our thinking or capture our emotions. At the end of the day, it is up to us. We live here together. We work here and raise our families here together. I urge those protesting on the streets to remember this. Peaceful protests are your right as an American citizen. Instigating violence and destruction are not. I've spoken with both Mayor Fisher and Governor Beshears in the days leading up to this announcement, and I urge them to do what is necessary to maintain law and order and to protect our cities and our people. We have a long road ahead, both as we pursue this case through the criminal system and as we address the pain in the Louisville community. I'm committed to being part of the healing process. When tragedy occurs, we must mourn. We must also do everything we can to prevent it from happening again. Today, Consistent with that view, I'm announcing that I will create a task force to review the process for securing, reviewing, and executing search warrants in Kentucky. The task force will consist of a variety of stakeholders, including citizens, members from the law enforcement community, representatives from the judiciary, defense attorneys, and elected leaders. I'll be issuing an executive order in the coming days to create this task force. I believe conducting a top-to-bottom review of the search process is necessary to determine if changes are required and establish best practices. You have my word that I will also vigorously prosecute the criminal charges announced today. I can assure you that my team of prosecutors will continue to give this case their attention and time. We'll also continue to support the good men and women of our law enforcement community who put their lives on the line every day to protect and to serve. And I will fight for those across our state who feel like their voice isn't heard, who feel marginalized, judged, and powerless to bring about change. In a world that is forcing many of us to pick a side, I choose the side of justice. I choose the side of truth. I choose a path that moves the Commonwealth forward and toward healing. You have that choice as well. Let's make it together. Thank you, and God bless. I'll now take some questions. I won't get into the specifics of the makeup of the grand jury.
Yeah, just you mentioned that Breonna Taylor was hit by 6 bullets. You identified the one that killed her. Who shot the other 5 bullets, and did any of Hankinson's bullets hit Ms. Taylor?
Based on the evidence, there's nothing conclusive to say that Detective Hankinson's, any of his bullets hit Ms. Taylor.
I'm just curious
Yes,
what
sir.
your message would be to the family and those who support her in the community, because based on what you're saying today, the grand jury basically found that none of the officers involved are directly responsible for Breonna Taylor's death.
Well, as I said from the beginning, and I appreciate that question, this is a tragedy. And sometimes the law, the criminal law, is not adequate to respond to a tragedy. And I fully acknowledge that, and I know many that are watching today and those that are listening recognize that as well. But the response is that the grand jury was given all of the evidence, presented all of the information, and ultimately made the determination that Detective Hankinson was the one to be indicted.
To be clear, did your special prosecutors make a recommendation to the grand jury?
Grand jury proceedings are secret, and so I'm not going to get into the specifics of details about that proceeding. What I will say is that we presented all of the information, and they ultimately made a determination about whether to charge. In this instance, they decided to indict Detective Hankinson.
General Cameron, one question.
Firing in self-defense, do you think state law needs to be changed?
I'm sorry, say that again?
When it comes to officers firing back in self-defense, do you think the current state law needs to be changed with cases like this?
Well, what my role as the special prosecutor in this case was to provide the information and facts to the grand jury. Detective Cosgrove and Sergeant Mattingly were justified in returning fire because they were fired upon. I'll leave it to others to make determinations. We have vigorous self-defense laws in this state, and that is something that existed prior to this case. I'll let others make judgments about that. Yes, sir.
One big question surrounding this case is whether or not the officers knocked and announced their presence. Talk about the evidence that you came to that they did announce their presence.
Yes, the statements that were made by officers there the night or the morning of March 13th show that they did knock and announce. The important point here is that information was corroborated by another witness who was in close proximity to Apartment 4, who corroborated that information. and said that there was a knocking and announcing by the officers.
Was the witness a civilian or a law enforcement?
The witness was a civilian.
If a warrant endangerment takes place while there is a death involved, would that not be a manslaughter charge? If there was a death that occurred during a warrant endangerment?
Well, Chris, to your question, I think it, again, is important to step back and recognize that what we did was uncover all the information and facts related to the morning of March 13th, and then provided that information to the grand jury. The grand jury had every piece of detail needed to make their assessment and their judgments. And ultimately, their conclusion was that the decision needed to be made to indict Mr. Hankinson.
Mr. Cameron, Rukmini Kalimaki with the New York Times. Right here,
I'm
sir.
sorry, yes, ma'am.
Hi, 2 questions for you. Number 1, you said that she was shot 6 times, yet her death certificate says 5. Can you please explain the discrepancy? And the second thing is journalists in this room, myself included, have taken apart that apartment complex looking for witnesses to the point that you made about the knocking and announcing. Of a dozen witnesses that I spoke to, only one, a man who was directly upstairs, heard them announce. Do you think that's enough in the middle of the night when somebody is asleep for just one person in a tight-knit apartment block to have heard that? Is that a sufficient way of announcing?
Well, let me try to answer your second question first. Your question was, it is enough for me. I think the more pertinent question is, what was the evidence provided to the grand jury? What was sufficient for their purposes? They got to hear and listen to all the testimony and made the determination that Detective Hankinson was the one that needed to be indicted, knowing all of the relative points that you made. As to your first question, can you repeat it one more time?
Her death certificate says 5, and yet you are saying 6. Today's the first time I'm hearing 6.
Yes. So there is a bullet that was lodged, and bullet might be too generous a term. There was an object that was lodged into one of her feet, and so that is what is being referred to as the 6th, I guess, projectile.
Are you going to release the full?
Joe?
Are you going to release the full grand jury report?
Can you say that one more time?
Are you going to release the full grand jury report?
Well, I am right now, because there is a pending indictment. I think it is our practice, and because there is an ongoing FBI investigation, to revisit that question. But at this point, I don't think it's appropriate for us to release any information.
And just for clarification, you said that Hankinson fired 10 times from outside into apartment 4 and into apartment 3, but no conclusive evidence any of those shots hit Taylor. Can you expand on that just a little bit more?
Well, that is what the evidence shows, is that there was nothing conclusive to demonstrate that any of his bullets hit.
Does that leave the door open for the fact that maybe one of his shots did hit her? Or?
Well, again, all the evidence was given to the grand jury, and they made the decision that wanton endangerment was the charge to file or to indict against Mr. Hankinson.
Okay, and thank you.
Yes, Wendy. Well, your last question about providing information. In any investigation, criminal investigation, the best practice, and this is whether on the state or federal level, is to not make too many specific comments about the investigation because you do not want to compromise that investigation. There are also ethical considerations as investigators and prosecutors that we're responsible to abide by as well. Some of those obligations continue now because we have a responsibility to pursue the prosecution against Detective Hankinson. It's my judgment very early on that we needed to take this case in the Attorney General's office. As you know, the Commonwealth's attorney was conflicted out of this case because of another matter that he was pursuing. I could have farmed the case out to another Commonwealth's attorney in one of our 120 counties. Instead, I did not do that because the resources that we have to bring to bear and the relationships that we have with our federal partners, in my judgment, were needed to uncover the truth in this case. And part of the reason the investigation took so long is because we needed to make sure that we were doing a thorough job of looking at all the facts and gathering all the materials, interviewing witnesses, making sure that all of our people felt confident in their presentation to the grand jury. I will remind you, as late as Friday, we were still interviewing people in this case. And so the length of it is because this case deserved thorough and fair analysis. That was needed and deserved by Breonna and by her family, for the officers involved, for the community of Louisville, and for the Commonwealth. We needed to have a thorough investigation. We also got the FBI involved in terms of the ballistics report. We needed additional, their ability to scrutinize and make an independent assessment as well. And so the length of the investigation was a reflection, I hope people understand, of how important it was that we got this right. We didn't want to rush it, and we did not. And I'm grateful to the team that is behind me for the work that they did. Look, over 200 years of combined experience. These are prosecutors and investigators who don't care about political distinctions, don't care about influence in any particular regard. What they care about is the truth. And we presented that to the grand jury.
Sir, sorry.
I'm sorry. I won't get into what our private conversation was. Yes, ma'am.
Yes. What do you say to people who say this is just another example of the Black community not getting full justice? And what specifically do you plan to do to calm a community that's long been hurting? And do you understand that anger that people might feel?
I certainly understand the pain that has been brought about by the tragic loss of Ms. Taylor. I understand that as a Attorney General who is responsible for all 120 counties in terms of being the chief legal officer, the chief law enforcement officer. I understand that. I understand that as a Black man, how painful this is. And which is why it was so incredibly important for make sure that we did everything we possibly could to uncover every fact. And I know, look, this team, myself, the members of the representatives of the Attorney General's office have taken a lot of criticism and scrutiny. But that scrutiny in many ways was misplaced because there was not a day that people in this office didn't go to sleep thinking about this case, and it wasn't a day where the first thing on our minds is getting to the truth in this case. And obviously, again, the criminal law is not meant to respond to every sorrow and grief, and that is true here. But my heart breaks for the loss of Ms. Taylor, and I've said that repeatedly. My mother, if something was to happen to me, would find it very hard. And I've seen that pain on Ms. Palmer's face. I've seen that pain in the community. And what our responsibility in the AG's office was to make sure that we uncovered every fact, that we utilized every resource that we could bring to bear to uncover the facts and the truth, and that's ultimately what we presented to the grand jury. On the question of what I'm going to do, I've talked to partners in the community about helping to be a constructive member of any conversations moving forward. I recognize in my remarks, I mentioned the fact that we'll be establishing a task force in the coming days ahead to look at best practices for warrants. So there is a lot that I can do in this platform to help.
Okay, sir, this is Maria Sacchetti with the Washington Post. Just had a couple of quick questions,
I
please.
hear your voice. Okay,
Hi,
yes, ma'am.
sorry, over
No,
here in
that's
the
okay.
back. Just wanted to double check, were manslaughter, did the grand jury ever consider the charges of manslaughter, reckless homicide? And if not, could you please explain why? And do you anticipate any other charges in this case?
I apologize. Could you say that a little louder? I
Sure.
think I got.
Sure. Did the grand jury ever consider manslaughter or reckless homicide or those kinds of charges? And if not, please explain why. And do you anticipate any other charges, or is this it?
I won't get into the specifics again of the proceedings themselves are secret, but what I will say is that our team walked them through every homicide offense and also presented all of the information that was available to the grand jury, and then the grand jury was ultimately the one that made the decision about indicting Detective Hankinson for wanton endangerment. I think that in terms of what happened the wee hours of March 13th, in terms of that particular or specific date and what happened that night in the apartment, I think it is unlikely that there will be any additional prosecutions that come from that event itself.
Attorney General, so can you go into the confusion over the fatal shot that was fired and kind of what the issue was there in terms of determining that? And then also, did you present the grand jury with any charges against Mattingly and Cosgrove?
Well, so as to your first question, what I think you asked about was
Confusion over the fatal shot.
yes, the reports that were provided to us by the Kentucky State Police and then the FBI as it relates to ballistics. So initially we got the report from Kentucky State Police and it was inconclusive about making a determination into that fatal shot. And so again, with the relationships that we have with our federal law enforcement community, and namely the FBI, I thought it imperative that we utilize that resource. And so they undertook an independent analysis and review of and conducted or provided a ballistics report. There is nothing that this team was able to glean suggesting that there was an objective reason for why FBI was able to conclusively or definitively state that Mr. Cosgrove fired the fatal shot. Both, again, KSP, their lab, well-regarded, well-respected, FBI, equally regarded and respected. That said, it certainly creates some issue in terms of providing that information to the grand jury and providing that at any subsequent prosecution. And so it was, from our judgment, important to provide both of those to the grand jury and then ultimately let them make a determination about what to do with that information.
And were they presented with
Yes,
charges for Mattingly or Cosgrove?
I'm sorry.
Mattingly and Cosgrove.
Say
Were
that
they
again.
presented with any charges for Mattingly or Cosgrove?
Well, what I will say is that they were walked through all the homicide offenses, and with that information and the information and facts that were provided to them that we uncovered in our investigation, they made the determination that Detective Hankinson was the one that needed to be indicted here. Yes, ma'am.
General Cameron, just a couple questions. First of all, does the Catholic doctrine apply at all in Kenneth Walker's defense of his own? The second question is, could you give me an idea of the percentage of people of color on the team of investigators presented to the grand jury?
So what I will say is there's obviously I don't want to get into the proceedings related to Mr. Walker. That's a separate, so I'm not going to have any comment on that. This team behind me presented to the grand jury. And your other question was about the racial makeup of?
Percentage of color of folks who are on the investigative team?
Well, I'm black, and I speak for the entire department. And I hope that will satisfy that question. Yes, ma'am. Yes, ma'am. I'm sorry.
I know that you said the investigation has obviously taken months and it was presented to the grand jury Monday. Can you tell us when did the grand jury actually, how long did they deliberate? Did they begin on Monday or did they begin Tuesday? And that was of this week, correct?
The grand jury was presented with the information today. I won't get into the specifics of when they began their deliberations, but I will say that they started early Monday and concluded sometime before noon. And so they heard everything they needed to hear. We didn't withhold anything from them, and I hope that satisfies your question.
Okay. General, can you tell me a little bit more about this task force? You know, Senate President Stivers and Representative Scott are introducing warrant bills for the next legislative session. Are they going to be on this task force perchance? And will you be taking some of the information from the bills they pre-file to work with on this?
Well, I don't want to put, obviously, the cart before the horse, but I did mention in the remarks that we are certainly going to have elected leaders on this task force, and I imagine that some of the policy questions and some of the policy proposals that have already been put forward and have entered into the public conversation will be a part of this task force. But I want to make sure that people recognize that this task force is being established not to demonize any one side or any one department or agency. I think it's a healthy thing for the Attorney General from time to time to be a part of a conversation with all 120 counties. I'm not talking or singling out any county specifically, but with all 120 counties about best practices that can be utilized. I had a recent conversation with somebody that said there is always room for improvement. I think that's important in any industry, important in any job. And so as part of my role as the Attorney General, I certainly recognize the part I have to play in making sure that all of our systems in government are improved upon, whether it be because of a particular matter that occurred or because from time to time it's just the responsible thing to do.
Did
Yes, sir.
any of the officers
I'm
ask?
sorry, Joe.
Yeah. Did any of the officers ask to testify or present evidence to the grand jury, and were any allowed to?
Well, what I'll say on that is, again, I don't want to get into the specifics, but testimony was heard by the grand jury of all sorts of witnesses and folks. And so, again, all relevant information was provided to the grand jury for them to make their assessment. Yes, sir.
When you look at the analysis of the path of the bullets, how was it that Kenneth Walker, who fired the shot at the officers, was not hit, and Breonna Taylor was hit so many times?
Well, that's part of the tragedy here. And again, I don't want to get into the specifics, but the fact that she was hit breaks my heart, and it breaks the collective heart of all the country. But I don't want to get, because we have now an open prosecution, I don't want to get too into the details of the trajectories themselves.
Two follow-up questions. One, I understand that the names of grand jurors aren't released, but what rule or standard prevents you from releasing the racial and gender makeup of the grand jury? And number two, you mentioned that Cosgrove fired the fatal shot, but could you clarify how many shots in all that hit Ms. Taylor were fired by Mattingly, and how many shots that hit Ms. Taylor were fired by Cosgrove?
Well, as to the last question, inconclusive in terms of how many shots from each officer. We weren't able to identify with that level of specificity. As to the question about the makeup of the grand jury, we might be able to, I need to confirm on that front about. Yeah, you know, the fact that this has received so much scrutiny I think it'd be inappropriate for me to share the information about the makeup of the grand jury, just to the extent I can protect them.
Will you release the investigative file or recommend that LMPD release it?
Well, look, the role that we now have is to pursue the ongoing prosecution against Detective Hankinson. And so I think it'd be irresponsible at this juncture for this office to release any sort of file, again, because we have this ongoing prosecution. And I'm not going to comment on, and I think I certainly shouldn't be recommending, again, because of the ongoing prosecution, any sort of recommendation as to relates to a release of a file.
We're going to have time for 2 more questions.
Oh, Daniel, okay.
You advise that you will not be influenced by outside people from other states. Does that diminish the actual pain that people are feeling down in Louisville throughout the state?
Well, I certainly don't think that whether it's the grand jury or our responsibility as the investigators or prosecutors, it's to find the truth. And so when folks from outside of the Commonwealth suggest or make their preferences or their opinions known, it should have no bearing on our role as prosecutor and as investigator and fact finder. Even with folks within the Commonwealth, again, this is a tragedy. I don't want to lose sight of that, but we do have a responsibility to look at the facts as they are, and we can't be in the business. I don't think we want a justice system that is in the business of fashioning facts or laws to a particular narrative. We have to be in the business of presenting the information to the grand jury and ultimately allowing them to make a decision about what to do subsequently.
Last question.
Yes, ma'am. Far in the back. I apologize. Actually, we'll take these last 2 here. Okay. So either one can start. Sorry.
I apologize. Thank you very much, sir. I wanted to ask if you, if you believe personally that someone should have been charged with homicide or one of the similar charges in this case, and if you could please walk us through what happened after the officers knocked on the door. Did they hear an answer? How long did they wait before everything erupted? But both of those questions, please, and thank you very much.
As to your first question, again, this is about what the grand jury decided. One of the misconceptions out there is that the Attorney General's office was in the business of making charges, and that's just simply not the case under Kentucky law. Our role is to present the information to the grand jury. We dispense with that responsibility. We did it after a protracted investigation that uncovered all of the facts. That was our role. That was our responsibility. And we presented everything to the grand jury for them to ultimately make a judgment about what to do next. And in this case, in this instant, they decided to indict Detective Hankinson. As to your other question about what was provided to the grand jury, I can't get into the details of the specifics on that particular issue. Yes, ma'am.
Yes, sir. In the beginning, you said that you spoke with Breonna Taylor's family today. I know you can't tell us word for word what they said to you, but how was the news received?
Well, it was a hard meeting, and I won't go any further. I won't elaborate. But it was a difficult meeting, and look, when I ran for this office, I ran because I had some singular ideas in mind, and you never know exactly what issues you'll be presented with and what challenges you'll be presented with. And today was one of those challenges, to have to sit in that room and provide the information to Ms. Palmer and to other members of the Taylor family. It's been a difficult day. This is a difficult day for everyone standing up here. This is a difficult day for those here that have to report this. And it's a very difficult day for Louisville, all of the Commonwealth, all of the country. I recognize that. And I certainly recognize the responsibility that I have to help in the healing process. And as I noted in my remarks, I hope that those that are home watching, those that perhaps have ideas about being angry or pained by this decision, I hope we will respond in a manner that respects our First Amendment rights, but also respects our responsibility as the Bible talks about loving our neighbors, and that we can do so keeping Breonna Taylor's legacy in mind, but also in a way that respects our Louisville, our city, the city I live in, that respects all of our communities. So again, this is a hard day. I am under no illusion that it is not. And all I can offer is that our office uncovered every fact that was relevant to the wee hours, the morning hours of March 13th. We provided that information to the grand jury, and you all now, whether you're sitting here or whether you're at home, know the results of that process. And now we have the responsibility to prosecute that indictment, move forward in that matter. But all of us have a responsibility to work together, to find common ground, to find ways to love one another, and just be good neighbors. And so that's what I implore as you all report on this in a responsible manner. That's what I implore those that are watching on television, is that we all have the responsibility of coming together now. I hope that you will take that charge seriously. Our governor likes to talk about Team Kentucky, and I believe him earnestly in that charge. And I hope that that extends to the results that were issued here today, and I hope that extends to all of our neighbors and all of our communities. Thank you, and God bless.